This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
We're joined now by Todd Lutsky from the law firm of Cushing and Dolan. We call the segment Ask Todd because you get to ask Todd whatever question you want about estate planning. It could be your estate plan, it could be a family member's estate plan, it could be an estate plan that you've yet to create. Phone line here is 888-205-2263, so get calling so that you can make sure you get in line to ask Todd your question. That number again is 888-205-2263. 2263. And again, we'll get to your questions in just a little bit. 888-205-2263. Get calling, and we'll get to you soon. Mr. Lutsky, thank you for joining us today.
Always a pleasure.
I was talking with my dad last night.
You were?
And,
what's going on?
Well, he doesn't believe in pencil sharpeners.
No?
He thinks the only way to really sharpen a pencil is to do it with a knife by hand.
A knife by hand.
And I got to say, he makes a good point.
He does. Yeah, that's true.
He does. Todd, let's talk a little bit about just what's probably a dumb question, but is actually a really smart question. So I guess it's a smart question.
Yeah.
How do you actually go about picking an estate planning attorney? I mean, there are thousands of them out there. How do you pick the right one?
Yeah, and I think that's a great way to look at beginning the estate plan, and it certainly leads into the guide we're giving away this month, which is the Back to the Basics. When I say back to the basics, that's part of it. If you want to get started, how do you get started? Obviously, you need to learn about the basics of estate planning, but you want to pick a lawyer. I have a 4-pronged test that I use, that you should use, or could use. Basically, you go into an attorney's office and you get the card. And the card will have the name on it, and it'll probably have the letters ESQ after their name. I think you should look a little deeper and see if there's 3 more letters, an LLM.
What's that stand
after
for?
The name. It's a Master's in Legal Letters for Taxation. I know it's LLM, not MLL, but that's the way it is.
Sure.
Law is always backwards. So it's an LLM in taxation, and they should have that because if you're going to do estate planning, it's all about taxes. And if you don't know taxes inside and out, you might not be the best estate planner. I'm not saying you're not. You still can be good, but to me, that's one thing to look at. Now, secondly, you say they don't really know why you're asking the question, but I would say, so how many, hours in your year do you spend doing estate planning? Good question. And they don't know why you're asking it. And the attorney might say, 70%. Okay, probably leave. Right?
Even at 70%?
Yeah. 100% of the time should be the answer.
Okay.
I really should. I mean, this is, have you ever tried to follow the Internal Revenue Code? It's not easy. I mean, it's hard for me to keep up, and that's what I do. I mean, to do other things and try and keep up with the Internal Revenue Code, I got to tell you, is hard. So, that's just, again, these are my rules of thumb. They're not anyone else's. And a couple other questions I would say, next, let's say you get into the estate plan and you start having the estate plan. And the attorney maybe does their planning, goes to a whiteboard. I don't know if they go to a whiteboard. I certainly go to a whiteboard. I draw pictures. I explain everything. And if they do that for you, and you leave more confused than when you came in, probably not a good idea.
Okay.
Maybe I'm looking at a second opinion. And fourth, cost. How much does it cost? Now, of course, it varies depending on what needs to be done, and I get that. But if they say hourly, I'd be a little leery, right? I'd go with flat fee. So, again, I don't know the numbers, but I'd go with a flat fee approach. So those are kind of my 4 prongs when I'm trying to pick an estate planning lawyer, and I live and die by that same analysis. Use it on me if you want to.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you have a question for Todd, The studio line here is 888-205-2263. This is your opportunity to ask him your estate planning questions live on air right now. That phone number is 888-205-2263. We're going to take a quick break here, but when we come back, we're going to get right to your questions with Todd. One last time, that phone number is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
Talking with Todd Lutsky, let's get right to your questions with him. First up, we got Jack in Waterbury. Jack, what's your question for Todd?
Okay, there's a large group of us in the country now. We're called senior orphans.
Uh-oh.
We're people that have outlived family and friends. If you write a will, who can you name as a candidate to administer your estate? For example, some states. There are some states I know that have created agencies that do exactly that, but the last time I checked, Connecticut has not. What can we do?
Yeah, and I'm not sure which states have those agencies or not. It is interesting to hear about senior orphans. I've never really heard that, but I guess I like the term. If you have no friends left because you've kind of outgrown a lot of the friends, I mean, I guess the first question is, and no family, who are we leaving assets to? So, if there's anybody you want to leave your asset to, I always want to look to people before I start looking to institutions or agencies like banks or brokerage houses, or, I want to stay away from the institutional investor, which is an option for you, by the way. An institutional trustee, but I try to find beneficiaries. So if there's a human that you're leaving assets to, maybe it's a niece, maybe it's a nephew, maybe it's a cousin, well, maybe you put them on to serve as personal representative or trustee of a trust if you're going to do it. So I'd look there. Secondly, I would probably say, well, I've got an accountant who prepares my tax returns. Well, the accountant probably knows how to do these things, or maybe the estate planning lawyer. Again, last resort. But at least the accountants and the lawyers understand the way to be a personal representative or to be a trustee. They understand the tax ramifications. They understand why a trust works and how it should work. So, a good option. Three, I would say, you could always look to the institutional investors or institutional trustees. Again, not overly thrilled with that idea, but it could be there. And you mentioned something that I didn't even know existed, where there's these apparently agencies that can serve. But I'd stick with, try to find that person if you can. Again, think about who you're leaving the assets to, and maybe one of those people can serve. So I don't know that I've solved your problem, but I hope I've given you some food for thought on that. And folks, that's a great question, because that's exactly what I'm talking about in my new guide, Back to the Basics. What I love about this is it's basically, if you get this guide, it's as if you sat in a meeting with me and had an initial consultation, because it's basically an engagement letter. It explains a fact pattern. It explains an entire recommendation for an estate plan, from the wills to the health cares to the powers of attorney to a trust, to how the trusts work. It talks about funding the trust, how to put the assets inside the box. It explains about fiduciaries, like this Jack was calling, trustees and healthcare proxies, and who they should be. And to me, it's basically going to help you figure out whether or not estate planning is right for you. You could put your fact pattern into this letter and see if it actually is a good recommendation for you. If not, at least it'll educate you on how to get started. Folks, Back to the Basics, new guide for the month, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I've got another one for you here. Let's go to Jeff in Florida. Jeff, what's your question for Todd Lutsky?
Oh, thanks for taking my call. And, Todd, thank you every week for doing this. It's valuable information. I'm sure we all really appreciate it.
Thank you.
My question is this: an irrevocable trust. My parents set up a trust for the kids.
Mm-hmm.
They being the grantor, we being the beneficiaries, about 20 years ago. And in that irrevocable trust, they put a bunch of securities.
Mm-hmm.
which have gone up in value. We're sitting at about a 70% gain.
Mm-hmm.
Now, it's my understanding that irrevocable trusts do not have a stepped-up cost basis upon the passing of the grantor.
Mm-hmm.
So we would be subject to heavy taxes in that irrevocable trust. My question is...
Let me stop you because that's a fallacy. So, and maybe you're right. I didn't draft the trust, but let me just interject here just because it's important. And I still want you to ask your question, so hold on a second. This is important for everybody out there. This is why this question is such a good one. The irrevocable Medicaid trusts that I talk about a lot, that we prepare at Cushing and Dolan, right? They are irrevocable, but there are many, many kinds of irrevocable trusts. And, Jeff, I'm not sure yet whether or not your kind that you have is one that is going to do this or not. But the way we draft our Medicaid irrevocable trusts they are incomplete gifts for gift tax purposes, and you retain mom and dads of the world, maybe your mom and dads of the world, retain the right to the income, among other things. And if you give away an asset and retain the right to the income, 2036 of the code says that causes the asset to be included in your estate for estate tax purposes because you did not cut the string. You kept that right to that income, so it pulls the whole asset back into the estate, not probate, but back into the gross estate. And why that's important, full step up in basis, eliminating the built-in gain on everything in there from stocks to real estate to rental properties. So my question to you, Jeff, is do your parents in that trust have the right to the income during their life?
I do not believe so, because my knowledge is that we have to do something because we're going to be hit with that stepped-up cost. We're not going to have the stepped-up cost basis. So
well, you better check
my question is, can they, when they are getting sick or they feel that, they're getting to the end, could they take money from their personal trust, let's say cash, and swap out the stocks for the cash so the stocks are sitting in their trust account and will be part of their estate, so when they pass, those stocks will get the stepped-up cost basis?
Let me ask you this. I'm going to answer that in a second, but let me ask you this: do you think your parents Mass residents?
No, right now they're in Florida. My mom passed away about 2 years ago, and my dad is in a assisted living. So
do you think they're worth more than $7 million?
Yes.
Okay. So maybe they did do some planning to get assets out of the estate. So for higher net worth clients, when we do irrevocable trust to get assets out of the estate so all the growth can be out of the estate, yes, that would receive no step up in basis. You trade off the capital gains tax for the estate tax savings. However, what they might not have known 20 years ago, and who would have, that the estate exemption would be as high as it is today. So because it's a $13.6 million exemption, we do make our irrevocable trusts with a 675 4C swap power in there, which simply means exactly what you said. The donor, mom and dads of the world, are able to reach into the trust and pull out assets as long as they put back assets of equivalent value. So if they have $5 million of stock in there and they want to pull out $5 million and put $5 million in cash in, home run, because now the assets in their estate will get to step up in basis. So, yes, look for that 675 4C power, a wonderful way to get a double bonus here from the planning that they did.
Mr. Lutsky, thank you so much for the time today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. If you've had a successful career and want to make sure you protect your assets, now's the perfect time to create a plan that will allow you to enjoy your retirement years. Cushing & Dolan's new guide is called Back to the Basics. a complete guide to an estate and asset protection plan. And in it, you'll get educated on important issues like how to avoid probate, passing your assets along to your family, and potentially eliminating your estate taxes. Don't wait. This free guide has all the information you need to build a safe and secure estate plan that will give you peace of mind as you close in on retirement. Call 866-848-5699 right now and request your free guide today. You can also request a no-obligation consultation to review any current planning you've done. Cushing & Dolan have been helping families like yours for 30 years. Let them help you too. Get their new guide called Back to the Basics today. Call 866-848-5699 or request the guide online by visiting LegalExchangeShow.com.